Thank you very much for that. And good afternoon to everyone. We have 3 hours to discuss a topic which is yet to be implemented in India. And we already have 20 participants who are interested in this topic. So what I propose to do is to discuss about the theory of what is group insolvency, what is the jurisprudence, how it has developed in India, and what is the way ahead in it. And we can, of course, everybody is aware that Videocon case is the first case in which this group insolvency was discussed in India, and way back in 2018. So when the IBC itself was like 2 years in existence. So let's go about discussing first the theory of that, then the what are the recommendations of the law which is going to come. So working committee was set up for discussing and for suggesting how we should go about in IBC, how we should go about having a group insolvency regime. Now, basis that there have been certain recommendations which have been made, although that has not become the law as such, which was expected, say, sometime in 2021 or something. But till now, we haven't seen any rules or regulations or any law as such regards group insolvency. But I think it's just a matter of time because that is the need of the hour. I would say it's already things are so complicated when we are working as RPs in so many cases. We see there are certain subsidiaries, associate companies, the assets are interlinked. Then the assets of one company may be given as security in some other case. One company may be acting as a guarantor for the others and so on. So it's already there. We are facing that every day when we are handling our cases, which are not group insolvency cases, which may be a standalone case. Say, suppose I'm handling the insolvency of a holding company. I have two subsidiaries. Now, technically, I don't have any right or control on the assets of the subsidiary. Whereas if those assets of those subsidiaries may also be given as security for the creditors who are on my COC. Now, there could be various issues which may arise out of this. To deal with all of those things, it makes sense to have some framework which will be there, which will deal with all these group companies, associate companies, subsidiary companies, and so on. The idea is, again, as we know, for IBC, it is a maximization of the value for the corporate debtor, be it in resolution or be it in liquidation. So some depend, obviously, it cannot be a one fits all kind of a mechanism. It will have to be something which is depending upon the situation or depending upon the group structure and so on, or the intermingling structure and so on. It will have to be decided in what manner that consolidation should happen, or whether it should happen or not in the first place. So let's discuss all of these things in today's presentation. I am not sure we will need the entire 3 hours because the material what is available itself for discussion is not that much. Secondly, we can also discuss the Videocon case law if time at the end of the session. And we can also have also the group insolvency, the framework which has been suggested, which has been recommended, that is also available. So we can discuss all of those things. I'll just start sharing my screen. I hope it's visible.
Yes, ma'am.
Thank you. Good afternoon, Saloni ji. Yes. So let us start with group insolvency as such, as a concept, not under IBC presently. What are corporate groups? So what we need to first understand is what will constitute a group. If we are to deal with something like a group insolvency case, then we need to first understand what is a corporate group. So corporate group is something which consists of multiple entities who are operating under a common ownership structure. They need not all be private or public limited companies. They may be different types of entities. It could be LLP, it could be a partnership, and so on. So all of these multiple entities can come together and can form a group of entities which may be having different characteristics. So as many groups, as many characteristics could be possible. So each entity within the group is considered as a separate legal entity under the law. So we know that a company is a separate legal entity. So the basic premise of any of the Companies Act, like we know, is that every company is a joint stock company is a separate legal entity which has its separate existence, which is separate from its owners and separate from the directors and so on. So even if all the there are no directors tomorrow or there are no shareholders tomorrow, the company will still continue in its existence. So that is what we have studied right from the beginning, that a company has a separate legal existence. Now, when we are thinking or looking at a group kind of a situation, and if we are trying to deal with a group kind of a situation under insolvency, then the basic premise what is considered before we even move on to the next step is that the whether that group, whether each entity in that group needs to be considered as or still continue to be looked at as a separate legal entity, or it has to be looked as a group as a whole. So again, a lot of issues are involved in that. Or even to reach that conclusion, whether you should consider it as a separate entity, each of those group of members, or you consider the entire group as a whole. So each of those are going to be that has to be considered separately in from a case to case basis, and that each entity, depending upon how we are going to look at those things, that is how it's going to be decided whether we are going to go for a separate legal entity criteria or we are going to look at the group as a whole. Now, these groups, when we are looking at them as groups, are again, like I mentioned, there are various challenges which are there, and treating the group entities as or those individual entities as completely separate entities, or considering them as a group as such. So those are the points which need to be looked into. Now, moving a step ahead from corporate group to an enterprise group. So this enterprise group is typically the I would say the concept, or the terminology which is used worldwide. If we look at the European Union, typically the European Union has very developed because it has been in existence for a long time, the laws of insolvency. So they have a very highly developed cross-border and a group insolvency regime there. So which is there over a period of time, and all of these concepts which are there of enterprise groups and what is control and so on, all of those are fairly developed in these nations, because it has been there in practice for a long time. So for us, these are not new concepts as such as in the business world as such, but as regards IBC, probably when we are dealing with insolvency of these entities, these terminologies will have to be looked at from a different prism now. First is when we are looking at groups, or if I'm looking at only as a holding and subsidiary company, I look at it more from a technical point of view sometimes, because I'm dealing, say, probably only with the subsidiary or only with the holding company as an IRP if I'm handling such assignment. But if I look at it from a group structure, or if I look at it from a case where I may have to look at all the 2 or 3 entities together, whether a holding, an associate, or a subsidiary company, then my perspective is going to change there, because I'm not going to be looking at only one entity and the assets of only one entity or the creditors of one entity also. I'll have to look at it as for all the entities. Then the decision will have to be made whether all the 3 entities have to be considered as one single entity for the purpose of this insolvency, which means that whether all their assets have to be pulled in together, or even though it is a group, each of these entities will be still considered as separate entities, and their process may still go on separately. Only there could be some internal discussions which may take place between the COCs of all the 3 entities, because there could be company transactions which are there, intercompany guarantees, maybe their intercompanies borrowings may be there. All of those things could be there. So these concepts as such, we are aware of those concepts. Only thing is we may not have applied them in the term of the insolvency when we are dealing with individual insolvency, or rather individual entity insolvency under IBC, that is only of companies. So enterprise groups, if we see, means there are associations of enterprises who are bound together by legal and or financial links and controlled by the group head. So now they are drilling down further from a group enterprise when they're discussing an enterprise group. So they're saying that it is an association of enterprises which is bound together by legal and or financial links and controlled by the group head. So that group head need not be a holding company only. Generally, it is the holding company, but it need not be the holding company. It could be any of the other group entities also. So that holding company will have these all other companies which are there in the group. And there has to be some association or some financial or legal link, say whether a holding subsidiary associate relationship, common shareholders, common directors, common control, or there could be various other financial transactions, like the related party transactions, which is the highlight, in every assignment that we handle. The related party transactions is something which we are required to look at in great detail. And the look back period also, when we look at the avoidance transactions, the look back period for these transactions is longer as compared to any other transaction. So again, this financial links is what is there between these group entities. And these financial links could be loans, could be sale purchase transactions, it could be borrowings, it could be guarantees, it could be any of the nature of any of these financial transactions which may be there between these entities. So generally, these entities or that group is controlled by one group head, as we discussed. It could be the parent entity. And if these entities or these enterprises could be located in one country, or they could be located in more than one country. If they're in more than one country, then it will be termed as a multinational enterprise group. If it is in the same country, then it will obviously it is there at the domestic level, and only one law will apply in that case. But where it's in case where the enterprises are located in, say, multiple countries, then again the complications of dealing with the laws of those countries also will come in. If it's only, say, in India, then only the IBC will apply, and it could be a fairly simple matter. Whereas if any of the group entities are present in any other country, and if we are looking at it as an enterprise group, then dealing with that situation will be a completely different ballgame. Then there could be more than one decision-making center, especially for policy decisions. But generally, the financial and tax management is centralized. So a typical characteristic of a enterprise group is that the policy decisions could be, if there are different divisions, each enterprise is having, say, or handling a different division, then those policy decisions may be separate. But the financial and tax management of generally of the group is centralized. Obviously, to take benefits of tax or whichever other benefits which may be available to that group, depending upon the nature of the industry and the country it is in. So various other benefits which may be available, they can be taken in a better manner if it is at a centralized level. So for financial and tax management. So again, we discuss this group where two or more enterprises or entities which are connected by control or by significant ownership. Now we have seen the definition of control. No, it's there in the Companies Act. It is there in your IBC also. It's explained in the IBC, and it is there in different other laws. So that the control definition is it's under the FEMA also, foreign exchange laws also. The definition of control has been given. So this is something which is relevant here, where to establish that one person or one entity has control over another entity, that is where that will decide whether it's a related party or not. We have seen the definition of section 5 subsection 24, where it gives such a wide range of relationships to establish that two entities are related parties. So all of those which talk about control and significant ownership and so on, all of those points will be relevant to establish whether these entities form a part of a group or not. Now, how to say that these are group entities, so that is relevant there. The group insolvency, as we have been discussing, refers to the insolvency process of some or all the entities of the group. Now, if a group may have some 7-8 entities, not all of them may be insolvent. Say only 5 have become insolvent. Typical case is Videocon group, where there have been 15 entities, and out of which 13 entities had all those commonalities which were decided in or which were upheld in that case. And basis that group insolvency was directed for the Videocon group as such. So some of the entities which are not insolvent, that is, they are solvent, they are able to pay their debts and so on, may also be inextricably linked with the other entities. So in that case, their assets may also be linked here. And even though they may be solvent, there could be a situation because of the structure of the group that even though those entities are solvent entities, those entities cannot be left out from this process. So sometimes it may happen that the solvent entities can also be included in the group or in the insolvency of the group. And sometimes categorically, if those solvent entities have nothing to do with, say, with the business structure or with the activities which are being carried on of the insolvent companies, they just happen to be group companies, but they're in completely, say, a different line of business. There are no intercompany transactions and so on. Then those solvent entities may be left out. So again, no law as such right now in India on that, but that would be typically basis what are the facts of the case. But then that possibility is there that the group insolvency may cover all or some of the entities, some of which may or may not be insolvent. And then either the assets and liabilities of all the entities are considered together as a part of single insolvency estate, or each entity is considered as a separate proceeding, and only procedurally administration of insolvency proceeding is coordinated. Now, this is the most crucial part of understanding the group insolvency process. There are two options. One is where all the assets and liabilities of all the entities in the group are pooled in. So it is like, what we call as a liquidation estate, where all the assets are put in there. So similarly, all the assets and liabilities of all the entities will be pooled in together. There will be a single entity which will be deciding as to how to go about dealing with the insolvency of that group as such. Now, the distinction of separate legal entity will fade away here, because we are considering all the assets and liabilities as a part of the single pool of assets, and the liabilities will be considered together vis-a-vis those assets. So all that will be something where everything is consolidated, all the entities are put together, all the assets have come together, and then that entire insolvency estate will be dealt with together. So it's not individual company, I have these 4 assets, the other company has these 3 assets. They'll not be, the resolution plan will not be discussing only with these 4 and 3 assets separately. There'll be only one resolution plan, which will be discussing with all of these aspects, all of this entire insolvency estate as one. Or the other option is where each entity, even though it is a group, each entity will be considered still as a separate proceeding, and only the whatever is required procedurally for the insolvency proceeding, that coordination will take place. So in the second option, the concept of your separate legal entity is still upheld. Each of those, say that 10 entities, there will be 10 insolvencies, there could be 10 RPs who are appointed for each of these 10 entities. Only whatever, because there could be some transactions which are common and some transactions which are going to be affecting each other, some guarantees may be there, some assets, liabilities may be interrelated. So only the procedural coordination will happen between, say, the RPs and the COCs of the 2 separate entities in the group. But for all practical purposes, they will be treated as different, as 8 different insolvency proceedings. So only there's a coordination between them, but there is no pooling of assets as such. So this is the critical difference, or I would say the primary difference between how we deal with group insolvency. One is where you pool on all the assets. Second is where you still go for separate separate proceedings, but only procedurally there'll be a coordination between the RPs and the COCs of each of these processes. Now, what are the complexities in group structures? Or why is it difficult to handle the group structures? Because of various issues which are there. And these are the issues which will, if these entities or these groups go into insolvency, these are the issues which are going to be faced by the IPs or the COCs when we are trying to resolve these units. And when we are looking at such entities which are a part of the group, and looking at the group structure, it becomes necessary that we understand what could be the complexities and what could be the different connotations which may arise. Because when we are dealing with such a group structure or such an entity in a group structure, then all of these factors become relevant, even though you may pool in the assets together or not, or you may go in for a separate individual insolvency, as in separate entity insolvency for all the entities in the group. Still, understanding the group structure, understanding the complexities, why that group structure is necessary, and what are the disadvantages. This is required because then we are able to completely appreciate how that structure is, and then how we are supposed to deal with it in case of insolvencies of such entities. So group structure can be either horizontal or it can be vertical. A vertical structure is generally within the same industry, and combine some sequential operations. So one after the other, there could be steps in the processes, because of which there could be different entities which are handling the process one after the other. So it's a vertical structure, say holding subsidiary, a fellow subsidiary and a sub-subsidiary and so on. So two different layers of subsidiaries are also possible. So that is generally known as a vertical structure. In a horizontal structure, we can, just imagine that this is a horizontal, this is a vertical structure and this is a horizontal structure. So could be one parent entity and has number of different subsidiaries or associate or other entities which are having cross holdings and which may be operating at the same level of process. So it need not be that one flows from the other. It could be all of them could be in the same industry. It could be in different industries. But they have cross holdings and they are operating at the same level. They could have a commonality of control. The holding company could be the same and so on. But generally, their operations may not be interconnected, as in one follows the other and so on. Now, as we are discussing that these layers are of companies. So then going through these layers and unraveling each layer and understanding that what follows what, who is whose subsidiary, who is whose associate company, what is the structure. Because obviously when we start any assignment as IP, the first thing what we do is we try to identify who are the related parties, right? So we, that 524, we have that list of who are treated as related parties. So when we are trying to establish these entities, these layers of companies which may be there, it may be difficult to try and look through them. So what we call as again piercing the corporate veil and looking into the nature of the holdings, under which category they will fall and so on. All of these things will require that we unravel those layers and we look at what is the essence of the relationship between that entity and the entity which we are handling. So that is how we will arrive at the conclusion of whether something is a related party and whether it forms a part of that group or not, and how are they interconnected, how are the relationships interconnected. So that these complex layers is something which we need to be vigilant about and which we need to be aware as to how we are going to deal with those, because it's not only whether something falls directly as a common directorship or as a common cross holding or a holding subsidiary or associate or something. Sometimes there are these hidden meanings which are there, like if you see 524 and if you look at some of the sub clauses in that, there are I would say generic, not vague, but they're very generic and which talk about very subtle things which may at the first trading or when we look at say a transaction between two people, we may not be able to actually put it under 524 in any other category. So because some categories are very easy to identify, common holding, common directorships, common shareholders and so on. But they're especially at the end, whether they're talking about ownership, whether they're talking about giving technical expertise by a person to the other, to the company and so on, which is something which is very case specific and which will have to be proved basis the facts of the case, because it is not, when a company has its own board of directors, it is very difficult to say that such a company is being or somebody else has a control on that company, because the board is supposed to function in the fiduciary capacity in the interest of the company and so on. But that board is accustomed to taking instructions from somebody else. That is also one of the criteria of being a related party, right? So it is very difficult that when you are having an independent board, how can you say that this board has been taking instructions from a person who is not on the board or who is not a shareholder or a director, but still the company is accustomed or the board is accustomed to take instructions from them. So it becomes very subjective to prove. So there are some of these clauses which are there in 524, where we need to go and actually, lift the corporate veil, look at what are the transactions which are there between these entities, and then only probably figure out whether this falls under 524 or not, and if it does, then under which clause. So if we all know the Phoenix infrastructure judgment, so in which they have lifted the corporate veil and seen that even though as on the insolvency commencement date, they were not related parties, but they went back in time, the court went back in time and found out that they're related parties. So something similar to that. So then that becomes a group structure. Then and the complexities which are there between those relationships then take a different connotation altogether. Because then we look at it from the avoidance transactions, we look at it from various other perspectives, which will give it a complete meaning when we are looking at all the different entities together. Other complexities obviously would be that there are family ties, there are common directorships, cross holdings by family members. Again, the relationships between these family members is again something which needs to be considered, not probably in the legal sense, but definitely in understanding how whether somebody is able to influence the other, whether somebody is able to actually influence the decisions being taken by the board, and is in a position like we have seen so many old companies which have been there in existence for a very long time, and where there is one patriarch of the family, and he is, even though he may be say a chairman emeritus, or he may not even be having any position on the board, but still the family will follow his instructions, or will follow his whatever he guides, and whatever decisions he takes. So this is something which is these family ties will have definitely a bearing on how the group is structured, and how the group behaves internally, or as regards the transactions between inter the group. So all of these things will be very relevant. Everything need not be on paper. You need not be able to have an ownership structure in that sense, but actions, or the minutes, the recordings, whatever is written, that is something which will help us to decide whether this is whether this will be a related party, whether it can form, whether this entity can be considered as a part of the group or not. Then other complexities can be raising of capital through cross guarantee financing. So each group member guarantees the performance of the others. So performance guarantee is very common in group entities. One company is going for a borrowing, some other company from the group will give the guarantee to the lenders for this loan. And then again, the assets will be charged. The security will be created on different assets from here and there. And then again, we will end up with a structure where you are actually not able to identify probably that whether this one asset is charged to only one bank, or it is charged to different banks. Because as soon as the guarantee is invoked, everything changes. And with that, lot of lenders may be able to give their or say that they have a right on all of these assets of the guarantor also. In that case, again, the priority of the charges for second charge, and so on, all of, or whether it's a pari passu thing, then again there could be some cases where the NOC of some previous lender has not been obtained, and so on. So all of these will give rise to other complexities, and when we are looking at it from the RP's perspective, then it becomes a headache for us in that sense, that how do you deal with whether the security on this asset, how do you categorize it, whether you need to look at it individually, or unless you look at it probably in a group structure, you may really not be able to identify or you may not be able to really deal with without pooling the assets together, say in the as a group insolvency. Then the financial and decision making autonomy, the centralized or decentralized decision making. So again, as we mentioned or discussed all these points, the financial and decision making autonomy may be with one of the, say, the parent entity, or it could be only some part of the decisions are to be taken only by a certain group of people, which could be, say, an executive committee or something. And otherwise, the day-to-day functioning is looked at by each of the separate entities separately. So again, that will play a huge role in deciding what is the structure, and who all are involved in that, and how do you deal with, what is the source of all the decision making, and so on. Other issues is again choice of a corporate form, whether the entity has been registered as a subsidiary, associate, as a branch entity, or and so on. So again, a branch, as we know, how do you deal with it as a separate legal entity, because it may not be categorized as a private company, it may not be categorized as a LLP, and so on. Subsidiary, straight away we can figure out what kind of an entity it is, but in some cases it may not be very easy to to look into the choice of corporate form and then include that in the group structure as such. So for the purpose of insolvency. Then cross-border issues, obviously, if there are entities who are in different geographical jurisdictions, and which is different laws are going to apply. So in India, IBC will apply, say in UK, something else will apply, New Zealand, something else will apply. Then for each of those laws, how is the consolidation happening? Then what is the difference in the local requirements of equity? There may be, like in Dubai, there's a requirement that you need to have a local person who, as a shareholder, you need to have a local person as a director. In India, we need to have a resident director here. So all of these things, they will be country specific, and they'll be, so when it reaches a cross-border thing, and then when we're looking at it from a group kind of a perspective, then all of these different transactions which have taken place in the past, in amongst this group, that will also be very relevant, because the raw material you may be purchasing from one entity, and it may be supplied to India, and which is being treated here, and the manufacturing process is happening in India. Now, all of these issues for the import, export, and so on, identifying it as a group, and again, the dependency, if that entity stops supplying me raw material, I may not be able to maintain my going concern status here. All of these things as a RP, we need to look into these, because uh, as we know, we are required to maintain the status of the entity as a going concern. Now, if it's a group kind of a structure, then whether everything, how to maintain all of these entities as a going concerns, how do you deal with the manufacturing, how do you deal with these issues of import export? You may not have, the company may not have been able to pay for the imports and so on. So all of those things are something which again will give rise to in such complex situations. The accounting requirements, of course, depending upon how many countries it is in the accounting may per se be similar, but then the tax laws will be different. Even for each different type of entity, say if it's an LLP, it may not require an audit until the turnover reaches a certain limit. Whereas for other, if it's a company, even if it is not carrying on any business, audit is required. So those accounting requirements and auditing requirements are different for each of these different types of entities. That will have to be factored in. Then what is the degree of integration of that group, or all the entities in that group? Economic organization, administrative structure. No, if sometimes what happens is you may have a common HR, you may have a common accounting team, or it could be common admin, common HR, and all of those things. So basically the support staff may be common. In such a case, it is a very close knit thing, because for each of those entities, all of these things are happening centrally. Some other functions could also be centralized. So all of those things will impact if the decision whether you want, whether it should be a consolidated group insolvency or an individual entity group insolvency. So that is something which will be, all these are deciding factors, and the complexities which will arise in once we start handling these matters, or even before the decision to put that into insolvency. So how do you put that into insolvency? All of these factors will also be relevant at that time also. Use of common trademarks, common advertising, common sales and logos. So, and whether there are any agreements to that effect between the groups. Now, there could be a single logo which is, or a trademark which is there, which is being used by the entire group, and there is no agreement or any understanding or nothing on paper that allows all of these group entities to use that logo, or to use those trademarks or other IP which is available. The advertising could be common. Then how do you differentiate all of this? And if you are not allowed to use, if you go into insolvency and you're not allowed to use that trademark, or you're not allowed to use that logo, then how will that company continue to be a going concern? Or how can it even function in day-to-day affairs? So all of these things will definitely need to be considered and have a huge bearing on how the group insolvency process needs to be approached. Then public image of the group, whether the people look at it as a single unit, or whether it is, even though it may be part of the group, each unit is identified separately. So say a Tata brand, Tata, we know the brand may be one as such, but then we know that they are into so many other things. So it need not be, the public image need not be that it is a single unit. The public image knows that it is a Tata brand, but they are into tea also, they are into hotels also, and a different, so it's a conglomerate, which is there in different lines of business. So as such, what is a public image? If they see something, or say Reliance for that matter, if they see Reliance, they don't only look at Jio. It is so many other activities or so many other industries which they have. So the public image of the group is again relevant, whether to look at it as a single unit or as separate entities. Now, of course, even given all of these complexities in group structures and how to deal with it going forward, when the group or that entity is reaching or is going into the insolvency, still the group structure is favored many times because of the various advantages which it offers to the promoters, of course, not probably from the point of view of the RP or from the point of view of the COC or the lenders, but definitely from the point of view of the promoters. What are the advantages for group structure? Is reduction of commercial risk. No, the risk gets spread typically among the different entities, and depending upon the nature of the business and the assets and so on, the risk can be diversified in that sense. Maximization of returns by diversifying. Then acquisition of other companies to expand, increase market power while preserving the acquired company as a separate entity. So even though it's a group, you maintain each of those, or you retain all those entities separately, and you leveraging the advantages which are there, you can still go for acquisition of other entities and to diversify, say, into newer lines of business and so on. You're having a group structure helps you to leverage that and be able to acquire more or expand more in that sense. Attracting capital to part of the business without forfeiting overall control. So if a new entity is coming in or if new entity is being set up, you can still maintain the control with your structure. So having, say, probably that a whole group holding company and so on, a parent entity, that helps you to still maintain again the taxation benefits and so on, everything you will are able to maintain the control in the manner in which you have thought about that. Lowering the risk of legal liability by confining high liability risk to particular members so that other group assets are isolated from the potential liability. So within the group also, high risk businesses and where there are higher borrowings are there, that could be kept separate. There, the group can be structured in a manner where these high risk businesses are not entangled with the other group. So the level of interaction is minimum with the other group structures, but still the advantages of the group can be taken. Groups are generally able, they have a better ability to provide for security for debt or project financing because they can show an entire group strength as such. You know, the number of entities and net worth could be higher, could be shown to be higher as such. The capabilities, the say, the number of employees and so on, your entire size can be increased in that sense and can be shown as such. Then the project-wise creation of entities. So for each, so like we see typically in the real estate business, for each project, there's a separate LLP which is created generally. So again, project-wise creation of entities, if you are having a group structure, that becomes simpler because you can segregate each project and you can segregate whatever the business is related to that, which does not generally then impact the other entities. Unless obviously there are cross holdings, unless there are cross guarantees and so on. Otherwise, for each project, a separate entity is created and that does not impact any other entity of the group. Simplification in case of a partial sale of business, only if one entity is to be hived off, only one entity has to be sold, one business is to be sold, it becomes much simpler rather than having all the businesses in one entity. Have separate entities and one of that entity can easily be transferred or sold. Tax efficiency, yes, which is like, you know, many times one of the biggest reasons for having a group kind of structure and having these cross holdings and, you know, so many layers of subsidiaries. So tax efficiency is one of the paramount factors which decides, you know, what kind of structure a group is going to have. Ease of meeting regulatory requirements for each group member. So having a group probably helps you to meet with your compliance and other regulatory requirements. You may have a say a team which is there, which is handling all of these regulatory requirements for each of the entities. A centralized say internal audit or whatever it may be can be handled in a centralized manner also, and that will the best practices again can be shared across the group and so on. Cross-border advantages of each geography for tax and local requirements. So if you're importing raw material, if you're having entities in different structures, you get the tax benefits there. The losses from there can be, you know, used to set off your profits here or vice versa and so on. So all of these advantages which are there, because if you're dealing with one country only, then only the tax everywhere is going to be the same. Whereas where you're if there are you're dealing with different geographical locations, then probably you may be able to benefit from whatever tax and other requirements may be there in each of these different countries. So now having understood the group structure, the advantages, what are the complexities, what are the factors which go into dealing with groups as such, let us discuss the groups under IBC. So in the Insolvency and Bankruptcy Code, whether there is a recognition of groups as such. So the IBC provides detailed provisions for insolvency resolution for each corporate debtor separately. So we don't have a group structure. There is no, although you can say that section 60 subsection 2 and 3 do provide for group insolvency, as in the section 60 subsection 2 talks about which NCLT has a jurisdiction and so on. So where they have said that the corporate debtor and a corporate guarantor and so on, the jurisdiction will lie with the same NCLT. Anything and any existing cases will be transferred to that one NCLT. So that is the only reference what is can be found as regards group insolvency as such. But there also it does not talk about consolidating those insolvency processes. It just says that the same NCLT which will have the jurisdiction. So the for the purposes of the guarantor as well as for the purpose of the corporate debtor. So apart from that, there is no reference as such for dealing with groups specifically or specially under IBC. So the provisions which are existing right now deal with insolvency resolution for each corporate debtor separately. Even if it's a corporate guarantor which goes into insolvency, still that corporate guarantor will be considered as a separate legal entity and will be considered as a separate corporate debtor for the purposes of IBC. So right now, there is no other provision which is there in IBC. The code lacks a specific framework for coordinating insolvency proceedings of different group entities. And each company within a group undergoes separate insolvency proceedings. So unless there is a consolidation like what happened in the Videocon case, even though a holding and a subsidiary company are undergoing insolvency, they will still be considered as a separate legal entity and separate insolvency proceeding. There may be two separate RPs. Each of the process will be different. The resolution plan will be different and so on. So as of now, under IBC, as far as the law is concerned, under the regulations, under the main code, there are no specific provisions which deal with the group insolvency as such. So like we discussed, so as regards insolvency in groups, the basic guiding principle is that each entity in the group is a separate legal entity. Now, group insolvency would mean going against it and to live the corporate will, because basic premise is that each entity is to be treated as a separate legal entity. Now, if I want to establish that this is a group structure, then I have to pierce the corporate will, or I have to live the corporate will and see how these two companies or how these two entities are interconnected, and then establish that this is, even though they may be legally they are separate entities, but for all practical purposes, it's the same entity or it's the same group and everything can be considered together. So that is something which is the basis on which we start with the discussion on or how to frame the law or what should be there in the law as regards group insolvency. Now, what are the influencing factors as when we are discussing how about the law or what should be there in terms of structuring of the law or what provisions need to be there or what needs to be considered when we are looking at a law with regard to group insolvency. Now, group structure, which may minimize the threat of insolvency to one or more group members by entering into cross guarantees, indemnities, and similar types of arrangements. So, the factors which influence in that sense how that group should be dealt with, consolidation or not non-consolidation, and all of those things. So if there is a group structure which minimizes the threat of insolvency to one or more group members, then there could be, by entering into cross guarantees, indemnities, and similar type of arrangements. So if you see, there could be various entities in a group where that group structure is such that A is giving a guarantee to B, B is also giving a guarantee to C, C is giving to A, and so on. So it is all, everything is like a mesh where there is kind of each of the assets are intermingled with the assets of the other entity. So in that case, the how to deal or how is going to be very critical, and that could be a deciding factor in for how to go about the group insolvency or even consider that as group insolvency. So that could be a deciding factor. Then when the problems do arise, a parent may seek to avoid the insolvency of other group members in order to preserve its reputation and maintain its credit in commercial and financial spheres by providing additional finance and agreeing to subordinate intra-group claims to external liabilities. What what they're trying in the working group to say here is that in case there are problems in the group, the parent entity, which could be the holding entity, the decision-making entity, they will try to protect their reputation or preserve its reputation and maintain its credit standing. So in that case, if one of the entities is going insolvent, the parent entity may step in and they may pay off, or they may seek credit, they may give additional finance or something to ensure that the entity which is in default does not go into insolvency. So something that is something which will help. So the group behavior as such, which will influence the going into insolvency or not, will be where the parent entity may step in to take all of these measures to avoid insolvency. Then majority of the domestic insolvency and corporate laws do not address the insolvency of enterprise group. As we have seen in India also, we don't have any specific legislation for that or specific regulations also for that. In the absence of legislative authority to the contrary or judicial discretion to intervene in insolvency means that each entity has to be separately considered and if necessary, separately administered in insolvency. If there is no recognition of an enterprise group and no specific authorities or no specific regulations made to deal with the group insolvency, either on a consolidated level or individual level, then there is no choice left to the regime but to ensure that each of the entities are treated separately and not as a group. Where the business activity of group members is closely integrated, the approach of consolidation may not work unless the parallel insolvency proceedings concerning all group members can be closely coordinated. So putting each company individually into insolvency, and when there is so much of interlinking which is there, then in that case, treating each entity separately may not work. There has to be some coordination between these entities or between the insolvency processes of these entities to arrive at a better outcome, which is again maximization of value for the stakeholders for each of these entities. Then how the insolvency of group should be addressed more comprehensively, and in particular whether and in what circumstances group should be treated differently from a single corporate entity. So again, depending on the group structure, depending upon what is the law in that particular region, and dealing with insolvency, and whether it is possible to treat each of these entities separately, or it is required that you need to treat them together as a group or only as one entity. That is going to decide how you are going to treat and how that process is going to be run afterwards. Degree to which the group is economically and organizationally integrated, and how that level of integration might affect the treatment of the group in insolvency. If they're totally interdependent on all the entities are interdependent on each other, and it is not possible to actually separate each one of them, and or if they're separated, then each entity may not be able to carry on its activities on its own. So that would ultimately lead to the death of that company, which is not the intent of the law. The intent of the law, IBC, is to try and revive that entity. So in such a case, there may not be any option but to treat all the entities or whichever are interconnected entities as a group kind of a situation and treat them in a consolidated manner. Extent to which a highly integrated group should be treated differently from a group where individual members retain a high degree of independence. So like what we were discussing now, if the group is so integrated that separating it would mean the death of the group companies, then it makes sense to have a group insolvency, a consolidated insolvency, as compared to a group insolvency where each of those individual entities will still be considered as a part of the group, but they will have separate insolvency proceedings for each one of them. And the assets will not be pooled, basically. Treatment of unrelated businesses and assets in the group, how if there are any unrelated businesses. So that is something where, like we discussed at the beginning, if there are two entities which are solvent or who are having completely different business, they just belong to the group, but the business is completely different. The assets are not given in the group, or the assets are not been pledged on, have not been given as security and so on. Then how do you treat those unrelated businesses? Whether they should also be dragged into this group insolvency unnecessarily, or whether they can be kept away because they are not going to add value to the insolvency process as such, and unnecessarily that running entity may be killed in this process. So that is a factor which is going to be which is relevant. Then whether the insolvency of one or more group members should affect the other members or the group as a whole, something known as a domino effect. So if one company goes into insolvency, probably because of the nature of their interconnection, this company stops working, that leads to the other company stopping its activities, leading to the third company also going in insolvency, or stopping its activities, or their activities getting affected. So whether insolvency of one or more group members can affect the insolvency of these other entities also, and in that case, whether everything is going to go insolvent, so whether the entire group is going to close down, this is also another factor which is relevant in deciding whether you go for a group insolvency, consolidated, separate, or whether you treat everything as or when you're preparing the law, how do you take these factors into consideration and then you draw the regulations. So like we have been discussing, in case of regulation of groups or for group insolvency resolution, there are two approaches, like what we discussed. One is a separate entity approach, whereby separate legal existence and limited liability of shareholders is recognized. And then the second approach is the single enterprise approach. So separate entity approach and the single enterprise approach. So first is the separate entity approach, whereby each separate legal entity is recognized as a separate legal entity, and the liability of shareholders is also, limited liability of shareholders is also recognized. So what we are talking about is the basic premise of a separate legal entity concept of for a joint stock company. So the separate entity approach recognizes that yes, that this principle should be upheld. Each entity should be treated as a separate legal entity. The liability of the shareholders is limited, as we know, to the extent of the amount which is unpaid on their shares. So that principle needs to be upheld. Other entities are not responsible for assets and liabilities of this entity and vice versa. Even though there may be cross holdings, there could be guarantees which have been given, still the entities and B will not be responsible for the asset for the liabilities of asset A of entity A, and vice versa. So each entity is responsible for their own assets and liabilities, and there, even though there may be cross holding, they cannot be clubbed together. Debts and assets of the group cannot be pooled. So like basic requirement is where we are going for a consolidated approach is where the assets need to be pooled. In this case, the approach says that each is a separate entity. They are not responsible for the assets and liabilities of the other entities. So debts and assets of the group cannot be pooled together. Then books may not be consolidated to determine the profits. So they need not be always a holding subsidiary kind of relationship. It could be just group entities, and the books are not being consolidated to determine the profits, or even if they are being consolidated, they are being done that only for the legal requirement. Where it's a holding subsidiary or an associate or a joint venture company, and for the purpose of Companies Act, the books need to be consolidated because that is a requirement under law. However, to determine the profits of each business, these books are not consolidated at the internal level. So something which is which typically means that each entity is treated as a separate entity, each business is treated as a separate business. So this is the separate entity approach. Now we look at the single enterprise approach, which means that the entire group is considered as a one single economic unit. So that's a basic difference. Single enterprise approach means only one economic unit. So this approach relies upon economic integration of the group members, treating the group as a single economic unit that operates to further the interest of the group as a whole rather than of individual members. So again, there could be cross holdings, there could be different number of entities, different types of entities which are there, and as a whole that group will operate. It is not like only one company A is looking after its own, only its own interest. There could be the entire group is moving in the same direction. The entire group is so cohesive that it is not possible to probably separate each of the group constituents to show that this is a separate business. So the entire enterprise, the entire group is considered as one single unit. Group borrowing is possible with group treasury arrangement. So typically very huge companies or very huge groups will have a centralized group treasury arrangement. So they will be doing the negotiations and everything on behalf of all the group entities. So such a in case of such a single enterprise approach, you can take that where there is a group borrowing is there, and that group borrowing can be done only with a group treasury arrangement. So typically, if there are 10 entities in that group and say 4 are cash rich, and there are other entities in the group which are in need of funds, then these 4 cash rich entities will pool their money in that group treasury, and the group treasury from there on will lend it to the other group entity. So it is an internal borrowing only which takes place. They need not go to the other banks or other third-party borrowers, third-party lenders. It all happens within the group. So they have their entire treasury unit internally. So the excess funds lying with one entity are used to help the other entities. So again, it's something which is where there is a group approach. It's not like individual companies having their own profits and the other companies incurring losses, or it's having huge outside borrowings. They are being used internally. The funds are being used internally. Then assets and liabilities may be moved within the group as and when required. So it need not be actually a sale or purchase transaction, but then the resources are there. The resources may be used for different group entities as and when the need arises, and so on. Then intra-group loans guarantees may be entered into on preferential terms. So typically they will have good say borrowing limits, or they could have enjoy some other preferences, or they are able to borrow on preferential terms as compared to others. So that the advantage of that preferential terms is given to the entire group and not only to that one entity. It is given to the entire group as such, so which means that the group is being benefited out of all this. So again, that group is the key, and not each individual entity is not looked at separately. There is a lot of interdependency between the members of each of those groups. Now, if you look at which approach, whether the single enterprise approach or a group, that is one second. So whether single enterprise group or a separate entity approach, what approach is taken generally internationally? So in India, as of now, there is no law, so there is no question of having a in writing, some law which deals with which approach is to be taken. But internationally, some countries apply the single enterprise approach in certain situations by developing a law recognizing the exception. So they will treat the entire unit as a single economic unit, and the law is developed to deal with those situations, barring few exceptions. So exceptions generally are where there is a consolidation of group accounts, where there are related party transactions, the cross holdings are there, common management, insolvent trading, where the parent can be made liable for debts of the insolvency of a group member. So one of the group members goes insolvent, then the parent is made liable to pay for the debts of that insolvent group member. So these are the exceptions where only probably that separate entity approach is considered, but otherwise, generally you will see a single enterprise approach in most of the situations. Germany has divided group structures in different categories to allow them to operate as a single enterprise. So we know the single enterprise, which means a consolidated group, the whole group as such. So there in Germany, they have different group structures depending upon, so one is an integrated group. So based on direct and indirect voting power, parent controls the group of companies. In turn, the parent will be jointly and severally liable for the debts and obligations of that group company. So if there's a parent entity which is directly controlling that the group entity by way of direct and indirect voting power, then that parent entity will also be held to be jointly and severally liable for the debts and obligations of the group company, that is a subsidiary entity. So this is something which is known as an integrated group. Then there are contract groups, so which is based on inter se contract, which gives rights to the parent. So there could be in the first case there need not be any agreement which gives the indirect or direct voting power. That could be only by way of say shareholding. So somebody holding say 70-80% shares may be treated as a parent, and these rules will apply. In the second case, where there is a contract group, that parent is getting rights of voting, or getting rights to rule that or to that subsidiary on the basis of the contract. So the contract gives it say probably differential voting rights or some other rights to say appoint the board of directors and so on. In such a case, then there's the rights of the parent are arising out of that contract. So these are known as contract groups. And then there is something which is known as a de facto group. So one company exercises dominant influence over the other without a formal arrangement. There is no agreement between them. So it's a case where there's a patriarch and then he's taking all the decisions sitting in one entity, but he's still having control over the other entity through the parent entity. So that is where there's a dominant influence which is being exercised. So Germany recognizes three kinds of group structures. integrated groups, contract groups, and de facto groups, but all are there within the single enterprise approach. So again, there is no separate entity approach as such. You will see both of them are treated as one and the same. So if the subsidiary fails to repay the loans, then it's the parent which needs to step in and pay off those loans. So again, it's a single enterprise approach. In New Zealand, the directors of wholly or partly owned group companies may act in the interest of the parent company rather than own group company. So where there is a group structure and there are subsidiary or other entities which are there, and the directors of these subsidiaries again are required to act in the interest of the parent company rather than acting in the interest of the subsidiary company. So again, here there is a kind of a consolidation. Again, there is a single enterprise approach because then both are considered as one and the same. In the US, the laws ensure that policy underlying specific commercial legislation is not undermined by enterprise groups. Courts use it to avoid specified intra-group transactions to support intra-group guarantees. Courts can also alter priority of claims and liquidation of group companies by treating intra-group debt as equity or by subordinating intra-group debts to claims of external creditors. So again, what they're saying, in the US also, they're recognizing it as a single entity approach, where there are laws which ensure that the policy underlying specific commercial legislation is not undermined by enterprise groups. So just having a group structure and trying to take benefit of separate legal entities is not allowed. The courts use this structure, that is the single enterprise approach. They use it to avoid specified intra-group transactions and to support intra-group guarantees. So wherever intra-group guarantees have been given, and if one company is failing on that guarantee, then the other companies in the group are made to pay against those guarantees. Then the courts can also alter the priority of claims and liquidation of group companies by treating intra-group debt as equity or by subordinating intra-group debts to claims of external creditors. So we know section 53, right, and under IBC. So what they're saying here is that the courts have the powers there to change the priority. So if there is a group company which is there, so which say probably falls as a secured creditor or which is a financial creditor, the courts have the power to change the priority in payment of claims in case of a liquidation, so that a group company does not get payment in priority to say third party or external creditors. So, or sometimes by saying that the internal group debt, so that which is not a financial debt, but it is in fact equity. So in that case, they will be removed from the hierarchy and the other creditors will come in their place. So the courts have the powers to again treat these kind of situations so that it is still treated as a single enterprise group, and the companies or the group entities are not allowed to take advantage of their own wrongs, in the sense that if one company has gone into liquidation, say, and the other group entities are their creditors, they don't come out and the entire money is not taken away by them. There could be something which is left out for the third parties or which is left out for the external creditors here. So again, a single enterprise approach which is taken in the US also. Now we discuss these two approaches, right? One is a single enterprise approach and the other is a separate entity approach. Now this single enterprise approach is where you're treating the entire group as one entity. The assets are pulled in, the liabilities are pulled in, and so on. This is, in technical terms, is known as a substantive consolidation. So for all basic purposes, for the understanding and everything, is termed to be a consolidation, whereby all the group entities are treated as one single enterprise unit, which is known as a substantive consolidation. So everything is consolidated in that case. So only one process will run. There could be only one RP. There could be only one COC, and so on. So that is known as a substantive consolidation. In this approach, which is again the single enterprise approach, assets and liabilities of two companies belonging to the same corporate group are combined so that the companies are treated as a single entity. So again, the single enterprise approach. The treatment of the assets and liabilities of two or more group companies as if they were a part of a single insolvency estate. Again, pooling of the assets and liabilities. The results of this process is similar to a merger, as creditors of the distinct entities now become the creditors of the consolidated estate of the entire corporate group. All 10 group companies pool in their assets, pool in their liabilities, only one COC, only probably one RP, and this entire process will be run so that the creditors of all of these entities together become the creditors of this group. So the group is as a single, again as a single enterprise approach, it will be considered as one. So in USA, there is a celebrated judgment of Owens Corning in 2005. So this judgment has majorly contributed to the jurisprudence on substantive consolidation, that is a single enterprise approach. In October 2005, Owens Corning was a corporation and its subsidiaries filed for reorganization under the US Bankruptcy Code and subsequently developed a reorganization plan based on substantive consolidation of all the subsidiaries. So they had a single entity approach, they consolidated all of that, and they came up with a resolution plan or a reorganization plan, as they do it there, for the entire group as such. The district court granted the motion for substantive consolidation, considering that there were administrative efficiencies for the doctrine. So the district court allowed that. However, on appeal, the Third Circuit reversed the district court's decision and laid down the 5 themes which must be given due consideration while applying the doctrine of substantive consolidation. So in appeal, what the court held was that you cannot have a substantive consolidation in any case, like, in any of the cases which comes in, there has to be some criteria or the which need to be laid down. And only in those cases can a substantive consolidation be possible. So only in those cases can a single entity approach be used. So what are those considerations as has been laid down in the Owens case? First is that to respect the rule of entity separateness and to use the doctrine of substantive consolidation only in exceptional cases. So like which is said in India also now, that substantive consolidation should be an exception. It should not be the rule. So primarily each entity, you have to uphold the separate legal entity concept. So substantive consolidation can happen only in exceptional cases. So if there is so much of intermingling or interconnection, then only you can go for a substantive consolidation. Otherwise, each entity has necessarily to be considered as a separate legal entity and separate insolvency process needs to be carried on. The principles of limited liability and entity separateness cannot be violated merely because it is difficult to untangle the financial affairs of various companies in the group, in the corporate group. So they're saying only just because they're entangled doesn't mean that you can have to consider it as a single group only. Related party transactions happen in every entity. So treat each entity as a separate entity and deal with the related party transactions as such. Then the second factor which is there is that substantive consolidation is a remedy for those harms caused by the shareholders who have abused the principles of separateness. The doctrine of substantive consolidation was developed as a remedy for the creditors who had suffered harm due to the abuses of the corporate form. So that also needs to be showed. So it's like the group is there, the shareholders are there, which could be common and everything. And those now they're trying to take advantage of this substantive consolidation, which in some cases may not be helpful for the creditors. So unless it is helpful for the creditors and unless it is a remedy for the creditors who have suffered because of this separation of ownership and management, then only that substantive consolidation should be allowed. The third requirement is that mere benefit in the administration of a case cannot be the sole ground for applying the doctrine of substantive consolidation. Substantive consolidation cannot be granted merely on the ground that it is necessary for formation of a reorganization plan. So just because there is administrative convenience, you cannot have a group structure, you cannot have a single entity approach. Even also saying that you are going to have a reorganization plan, a common reorganization plan, that also cannot be a ground to consider substantive consolidation. It has to go something beyond that. Then substantive consolidation must not be used in a manner which is detrimental for a group of creditors. Consolidation order must not benefit a part of the creditors at the expense of the other. So basically treat all creditors fairly. It cannot be that say one type of creditors are being treated in a manner better as compared to the other creditors. So substantive consolidation should not be used for such purposes. Then substantive consolidation should be used as a last resort after rejecting the other remedies available in the group insolvency cases. So basically, single enterprise approach should be used as a last resort. For all practical purposes, the entities first should go for a separate entity approach. And only if that is there is no other remedy which is available, then only you use a substantive consolidation approach. So this is what has been held in the Owens case and which is widely recognized all over the world and used as a basis to deciding whether a substantive consolidation should be done in a particular case or not. Now, as against a substantive consolidation, the other concept is a procedural coordination, whereby the second approach which we said, which is a separate entity approach. So single entity approach was a substantive consolidation. A separate entity approach is the procedural coordination. So which means that each entity is considered as a separate thing. There could be different CRPs, different RPs, different COCs and so on. But there should be coordination amongst all of these stakeholders, because there is a lot of intercompany transactions and so on. And the group is in that sense close-knit. So each entity will have a separate CRP or a separate process which is there for resolution. But there should be coordination between the stakeholders. So that is what is stated in the procedural coordination, so which is also known as a separate entity approach. So procedural coordination means a set of measures which are intended to correlate the insolvency proceedings opened against the members of the group companies in an attempt at assuring harmonization of proceedings as well as cost efficiency. So again, separate processes will keep on happening, but there should be some harmony in this proceeding so that it helps each other. And there could be a cost efficiency, say common valuation may be done, or something like that. So because of which there could be a cost efficiency which is there in the process. And cost could also be reduced if there's a common RP also, then the cost, the fees of paying 10 different RPs as against that paying one RP, that in that sense. So the cost, there could be cost efficiencies also which may be achieved. Then procedural coordination includes coordination of the administration of 2 or more insolvency proceedings in respect of group companies. Each of those members, including its assets and liabilities, remain separate and distinct. So there is no common pooling of assets, there is no common pooling of liabilities. Creditors of one do not become the creditors of others. So for all practical purposes, 10 different insolvencies will happen, but there will be coordination amongst each of those 10 insolvencies. Procedural coordination prescribes for cooperation and coordination among different entities under insolvency. And resolution or liquidation process of different but connected entities are put under a common procedure. So only the procedural part is the same, whereby they take cognizance of the other insolvencies which are there and see how they can be work together. But for all practical and legal purposes, there are different insolvencies, different processes which are happening. Assets are different, liabilities are different, and so on. So procedural coordination, separate entity approach. The substantive consolidation is a single entity approach. Now, whether how to decide, or what are the factors to decide whether you should there should be a substantive consolidation or whether there should be a procedural coordination. So what we saw in the Owens group, this is something as an extension to that. The assets or liabilities of the group members are mixed in such a manner that it is difficult to identify the ownership of the assets and liabilities without disproportionate expenses or delay. So much of intermingling is there, the balance sheets are like mirroring and so on. So in that case, it may not be possible to identify who is the owner of which asset and whose liability is which liability without spending a lot of time or money. So it's not like prima facie you look at a balance sheet and you're able to understand. So in such a case, that may be a case to go for a single entity approach or a substantive consolidation approach. If the court is satisfied that the entities of the same group are engaged in fraudulent activities and substantive consolidation is essential to rectify such an activity, then in that case also substantive consolidation may be directed. Hindrance or fraud on creditors, bona fide reliance of creditors on the entire corporate group, the intermingling of corporate assets and accounts, and if the consolidation would be in the interest of the creditors. So again, the interest of the stakeholders need not be the promoters, the other stakeholders is paramount. So if there has been fraud played on the creditors, if the creditors are relying on the entire corporate group as such, and basis that they have been lending money, the assets, the estates accounts, the assets, liabilities, everything is intermingled, then in that case, that could be a case for going for a substantive consolidation. Then consent of the creditors is a crucial factor, as the pooling of the assets and liabilities interferes with the existing rights of the creditors. Obviously, because each creditor will have, say, a specific right, an exclusive right on certain assets as a secured creditor. Now, if there is going to be a consolidation and when the resolution plan is likely to come, his rights may get affected, because the plan, what he would have got, say, individually could be different as compared to what he will get in that after the assets and liabilities are pooled. So his voting share may also go down depending upon the other liabilities in the group. But then that unless without doing that, if the value is not going to be maximized for that creditor also, then it makes sense to go for a substantive consolidation rather than a separate entity approach. Then a substantive consolidation is a remedy for the creditors and must be used only if it furthers the objective of creditor in possession. Otherwise, there is no value addition or maximization which will come from a substantive consolidation. Then it is better to go for a separate entity approach if these benefits are not going to come out of it. Now, let us look at the Indian jurisprudence, whether in India, what has been the law as regards group insolvency. So, of course, we know that there is no provision in the code. There is nothing in the regulations also which talks about this insolvency, the group insolvency. But there have been few cases in which the Indian tribunals have held, the NCLT or the NCLAT has held that this is a fit case for a group insolvency. The first case obviously being that of Videocon. So here I just have a summary. At the end, we can discuss that case in detail. But here we have a summary of the Videocon judgment. So which was a judgment which came in August 2018. So just less than 2 years after the code was made effective. And now it's almost 5 years. So we are in August 24. So in 5 years, we have a working group report, we have a recommendation, but we still don't have a law which talks about a group insolvency. But 5 years before that, now this judgment had come in which talked about the group insolvency for the first time. So during the insolvency of Videocon Industries, a consortium of banks led by State Bank of India, being the common creditor, filed an application before the NCLT Mumbai seeking substantive consolidation of 15 Videocon companies into single proceedings for the purpose of CRP to form a common debtor. So there are 15 entities against which insolvency proceedings had been filed. SBI was a common lender to all of them, and SBI filed an application saying that all of these 15 insolvency should be brought in before the NCLT Mumbai only. Before the same bench, there should be a common proceedings. All the assets and liabilities should be pulled in, and it should be treated as a substantive consolidation. The NCLT Mumbai permitted the consolidation of the insolvency proceedings of 13 out of 15 entities in the Videocon group on the grounds that the operations of these entities were linked and the entities were also involved in availing loan facilities under a composite agreement. So out of 15, the bench agreed to bring in 13 under the substantive consolidation. The NCLT Mumbai, relying on the precedent from USA and UK, so a number of judgments of these courts were submitted before the NCLT to help the NCLT to take a decision. They held that group insolvency may be permitted where there is a evidence of common control, assets, directors' liabilities, interdependence of the companies, interlacing of finance, pooling of resources, coexistence for survival, intricate links between the entities, intertwined accounts, interlooping of debts, singleness of economic units, and common financial creditors. So, in a way, this Videocon judgment has laid down the law for group insolvency in India and have said that if these factors are there, if there is evidence of all these 10 things being present in a particular case, then it is a fit case for group insolvency. Then again, Mumbai bench, the same bench in the case of Lavasa Corporation also permitted the consolidation of insolvency proceedings of Lavasa Corporation and its 4 wholly owned subsidiaries, including 2 subsidiaries that were not undergoing insolvency resolution, subject to the approval of their creditors. So out of these 4 subsidiaries, 2 were already into insolvency, 2 were not in insolvency, but subject to their creditors' approval, the bench put all the 4 in the group insolvency process. The NCLT based its decision on the fact that the debts of all the 4 subsidiaries were guaranteed by Lavasa, and the resolution plan was conditional on the consolidation of the insolvency process of all the entities. So the resolution plan which was there said that unless unless all of those entities are considered together, and all of the resolution plan cannot be fruitfully implemented or approved. So that is why all the 4 end subsidiaries along with the Lavasa Corporation were taken together. The NCLAT has also permitted in the Edelweiss versus Sachet infrastructure case. So the NCLAT has also permitted a form of group insolvency for 5 entities who jointly owned a plot of land and were operating as a consortium in this particular case. In this case, the NCLAT directed that the CRP of 5 entities occur simultaneously through a single resolution professional, so that he is able to handle all the 5 insolvencies and treat them as one. And also, it was a home buyer's case. So again, it was much easier to coordinate and it was much easier to carry out the insolvency as a single process. Then in the matter of Chitra Sharma versus Union of India, the Supreme Court has directed the parent company, that is the JP Group, to deposit a substantial amount in lieu of the insolvency proceedings initiated against its group company. So even though it may not be directly as such said to be a group insolvency case, in the sense that other entities are also put into insolvency together, here the Supreme Court has lifted the corporate veil, if you can see, and said that the parent entity in the JP Group was required to deposit a substantial amount towards the insolvency proceedings of the subsidiary or the group company. So since there could be internal guarantees and so on, the parent entity was made to deposit that money. Then in another case, while exercising its powers under Article 32 of the Constitution, the Supreme Court in Bikram Chatterjee and others versus Union of India came to the aid of the aggrieved home buyers by ordering attachment of properties of all 40 group companies in the Amrapali group and freezing of bank accounts of all companies and their directors. So not again directly straight away related to say a group insolvency situation, but again the corporate veil was lifted and all the 4 entities were brought into the process by way of freezing their bank accounts and the bank accounts of the directors, and the aggrieved home buyers were in that sense given a relief by attaching the properties of all these 40 group companies also. So this is about the Indian jurisprudence. From here, we are to start the what is the model law in India, but I think let's take a break here and come back in say 10 minutes. To continue with this legal, the framework which is there. Anybody has any questions or comments till now to add? Anything in the chat box? Okay, Mr. Sharma has said. Recently, I was engaged as IRP in a group insolvency real estate matter, presently under stay by NCLAT. I got an opportunity to publish 3 forms, one each for 3 CDs. Land was allotted in A CD, development collaboration between A and B, and later on construction, marketing and sale by C. Hence, there is a possibility of FCs in all 3 CDs. I might have to carry out the CRP as IRP subject to the vacation of stay by the NCLAT. Following points need to be clarified. Okay, many points are there. Okay, claims to be collated and verified individually for each CD or to be considered as one CD, one COC to be constituted or 3 separately. It will be treated as one case for IRP or 3 matters. Can IRP charge fee from 3 CDs separately or one invoice only? The procedure to be followed after constitution of COC, like 1 or 3 IANS, UI, RFRP, and so on. Okay. Okay. So we'll discuss this after the break. So we are at what, 4:25 now. So let's meet again at 4:35. And so we would also like to hear your experience if you have already started working on this even before the stay was granted. So we would also like to understand your experience of how you went about at the beginning of the process. Yeah, can we resume?
Yes.
Yes, ma'am.
Yes, sure. Thank you. So let's discuss the legal framework. And we'll look at the components of what has been designed or what is being proposed to be designed in India. And then we will look at what are the recommendations which have been given. So the legal framework, as we know, ANSI is generally the authority which drafts all these model laws, which is generally accepted all over the world. Most of the jurisdictions will just adopt the model law which has been recommended by ANSI, and then with whatever suitable modifications are required to be made for the local jurisdiction. So accordingly, the model law on enterprise group insolvency, which is known as a model law, was introduced in 2019, which was framed by ANSI. Now, India has not adopted this model law. So the IBBI had already set up a working group on the group insolvency, and that working group, along with MCA, had already started drafting a legal framework for the group insolvency law in India. When this ancestral model law came in, again this working group also worked on the model law, so they took inputs from the model law also. And basis that there was this committee which was Cross-Border Insolvency Rules Regulations Committee, CBIRC. So along with MCA, IBBI and that working group, this CBIRC has issued a report proposing the implementation of a group insolvency framework in India. So this committee went through all of these model laws, whatever other workings and papers were there, whatever jurisprudence had been developed till then. So this happened in sometime in 2021. So whatever jurisprudence had been developed by them by then in India, all of those things were taken into consideration, and a report has been issued which says that the group insolvency framework must be implemented in India, and how to go about that, and what are the factors which need to be considered for that. So the CBRC has analyzed the legal framework for consolidating the assets during group insolvency in the US and the UK and other jurisdictions, and based on its examination, did not recommend adopting the model law. So the ancestral model law, they have recommended that we should not adopt that ancestral model law. We should have a law which is more tailor-made for our needs in India. Instead, the CBIRC proposed its own framework for group insolvency. So it may have borrowed certain things from that model law, but it is completely tailor-made to the Indian requirements. Now, the CBIRC has identified two key aspects of group insolvency. Again, what we have discussed, the substantive consolidation and the procedural coordination. So there the report says that a substantive consolidation, that is the consolidation of assets and liabilities of two or more group entities into a single insolvency estate, and a procedural coordination, that is the coordination and synchronization of concurrent insolvency proceedings of group entities. So parallel proceedings which take place for various entities. The report suggests that any framework for group insolvency should be voluntary, it should be flexible and enabling in nature. And with this objective in mind, the report also proposes a draft framework for group insolvency, incorporating the procedural coordination mechanisms, which should be implemented only in a phased manner. So they have completely ruled out the model law. They have completely ruled out the substantive consolidation for India. They are saying that we should go for a procedural coordination mechanism, and that framework should leave a choice, or rather it should be voluntary, flexible and enabling in nature, so that it need not be made as a mandate, but in fit cases, the NCLT should have the flexibility to direct a group insolvency for a particular case. Now, according to CBIRC, the substantive consolidation should be resorted to only in exceptional circumstances, as it deviates from the settled principles of separate legal entity or incorporated entities and limitation of liability. So this we also discussed. So the same drawback they have mentioned here. The CBIRC has therefore suggested that provisions for substantive consolidation be formulated at a later stage after the Indian jurisprudence has evolved further. So they're saying that at this stage, India is not ready to have a substantive consolidation. We should go for a procedural coordination, see how it goes, and then after that probably consider whether we can have a law on the substantive consolidation portion also. So jurisprudence on substantive consolidation, that is the pooling of assets and liabilities of an insolvent group, is already developing under the code through the case law. So a Videocon case is a fit example of that. This is a remedy resorted to in exceptional circumstances, and provisions governing substantive consolidation may not be provided in the code at present. So what the view is that since the courts are already using that in fit cases, it need not be codified under the law. It can be used as and when required in very exceptional circumstances which have been recognized by the NCLT in previous cases. So only we should go for a the law should be related only to the procedural coordination and not for the substantive consolidation as of now. Now, in the report as regards the procedural coordination, what they're saying is that the group insolvency may be initiated by the corporate debtors or their creditors filing a joint application before any NCLT, exercising territorial jurisdiction over any of the corporate debtors. So, right, we know, right, that the CRP or the petition can be filed before the NCLT where the registered office of the corporate debtor is situated. Now, in case of a group insolvency, there could be different entities which are there in different states. So, in that case, the territorial jurisdiction of the entity could be different. One company is in Maharashtra and one company is in Delhi. So, the territorial jurisdiction could be different. So, what they're suggesting is that the group insolvency may be initiated by the creditors by filing the application, a joint application before any of the NCLT. So, it could be either in Mumbai or it could be in Delhi. So, that is left to the creditors. And the application will be obviously for initiating the CRP against entities belonging to the same group. So it will be a joint application, or to initiate group coordination proceedings between two or more corporate debtors undergoing CRP who belong to the same group. And that is that already if it's there before any other benches, that can be consolidated or that can be brought before a single bench. And the solvent members of the group should be excluded. So even though applications are being filed against these entities which are insolvent and as a group as such, but the entities which are solvent in that group, the application should not be filed against those entities, or those solvent entities should be completely excluded from the process. Then we look at what are the recommendations in that report. So how the recommendations are about what that model law should contain, what all should it deal with. So it says the CBRC recommends that the group should be defined so that it is easy to identify what is a group and how to recognize whether a particular entity is a member of that group or can be considered to be a member of the group or not. So they're saying that the definition of group should be given and it should be on the basis of control as defined in the Companies Act and significant ownership in terms of the Competition Act vis-a-vis two or more corporate debtors. The definition should be applicable to all entities that fall within the definition of a corporate debtor under the code, that is companies and LLPs. The group insolvency framework may not apply to financial service providers under 227 of the code at this stage. So right now they're saying that FSP should be kept out of the process. Only the other corporate debtors, that is the companies and LLPs, can be included in the group or can be included in this framework. And again, the group should be defined basis the control and the significant ownership. So that definition has to be clear. Then the group insolvency framework under the code should only apply to corporate debtors in respect of whom a CRP or liquidation process is ongoing. The law shall not apply to solvent members of the group. So either the process is ongoing or it has been filed against the company. So if the petition is filed, law shall not apply to solvent members of the group. So exclude all the solvent entities. Filing of joint applications for initiation of CIRP against multiple corporate debtors belonging to the same group may be permitted. Such applications may be filed with the adjudicating authority that has territorial jurisdiction over any one of the corporate debtors in respect of whom such joint application is being filed. Although filing jointly may be permitted, the application form for each corporate debtor should be separate. So joint applications, say there are 10 companies in the group, you will have 10 applications, but they will be all jointly filed. So application form for each corporate debtor should be separate. So which will identify the corporate debtor, the loans and so on, everything. But it will be a joint application, say being filed by a particular lender. And it will be filed with any of the NCLTs in the sense wherever at least one of those group companies has a registered office, at least one of those entities should be falling within that jurisdiction. So then the NCLT, that NCLT will have the jurisdiction to deal with these group insolvency cases. Then all proceedings related to corporate debtors belonging to a group may take place under the same adjudicating authority. To give this effect, all pending applications and proceedings under the code in respect of a group member may be transferred to the NCLT. That is the first to admit an application for triggering a CIRP in respect of any CD belonging to the group. All new applications in respect of any group should also be filed in such NCLT. So giving jurisdiction only to one NCLT if suppose the applications are filed at say at different points in time. And if already one NCLT has admitted an application against one of the group companies, all other pending applications should be transferred to that particular NCLT. And only that NCLT will have the power to decide as regards all the companies in or all the entities in that groups. Any new application which will come in should also go to that NCLT only irrespective of the territorial jurisdiction. Then participation of the corporate debtor. So these are the recommendations of the committee. Participation of the corporate debtor in the group coordination proceeding should be voluntary. The COCs may have flexibility to opt into the group coordination proceedings until 30 days after its opening. Any opt-ins after such time may be permitted with the approval of the participating COCs and the liquidators. For such approval, each COC would have to vote in favor of such opt-in by at least 50% of each of their voting shares. Participating group members may opt out of the group coordination proceedings at any time until a group strategy has been approved by the respective COCs. And if we see the language and if we see what all flexibility has been given, I think this will lead to a very chaotic situation. Imagine or look at it from the point of view of us as RPs when we are handling these matters. So the participation of the CD in the group coordination proceeding is voluntary. The COC will have the flexibility to decide whether they want to participate in the group proceedings or not. Now, if that is, if the flexibility is given to the COC, then look at the difficulties or the practical issues which may arise for us as regards the participating in that group process. Then some of the COC members may be in favor, some may not be in favor. 50% approval is required. I mean, at least 50% of by using the voting share, they need to agree to join the proceedings. But then 50% is a very less number as such, it's ultimately only a simple majority. So how do we deal with those things? If there is a majority, if there's a 49% COC member saying that we don't want to participate in the group and a 51% member is saying that yes, we want to participate, and it will go into litigation afterwards. Even if the resolution is passed, because there's a substantial chunk of the COC which is not agreeing to participate. This may lead to a lot of headaches, in the practical implementation. But anyway, these are still at the recommendatory stage. So we can just hope that when it actually is brought out, these things will be ironed out in that. Then the participating group members may opt out of the group coordination proceedings at any time until a group strategy has been approved by their respective COC. Now those group members, by what percentage can they opt out and so on, again, that will have to come in the fine print or in the procedure of the regulations aspect. And within 30 days, the COC needs to decide that as soon as the COC is found within 30 days, they need to decide whether they want to participate in the group insolvency or whether they want to have their own insolvency process separately. So it's like section 52. Rather than when they're filing the claim, in liquidation, they need to inform whether whether they're participating, pooling in their assets and so on. So something similar is proposed here. Then a group coordinator shall constitute a group COC consisting of suitable representatives from COC of all participating members. So what is suitable representatives? We don't know. Then again, who will, so it's more like having a lead member of a COC, right? So that lead member of the COC will represent the COC of a corporate debtor on the group COC. So what they're trying to say is that there could be, if there are 10 group insolvencies which are happening parallelly, 10 different entities, the COCs of all these 10 entities will have a group COC. And say probably some members from each of these 10 COCs will be represented on the group COC, and that group COC will function as such, and it will be like that authorized representative thing, but on a very different scale. So each of these group COCs, the representative from here will be there on the group COC. Whatever discussions take place within the group COC, they will have to relate back to the respective COC. And then again, there could be reasons or there could be infighting who will go on the group COC and so on. So probably who will be the lead member and so on. Those issues may arise. Then the group COC in group coordination proceeding may perform functions delegated to it by separate COCs. However, the power to approve a resolution plan shall not be permitted to be delegated to the group COC. So the group COC is only going to say probably take policy decisions in that sense, but cannot approve a resolution plan. Maybe it is more for a coordination as to how between all the 10 different COCs. So it does not have in that sense a power to approve a resolution plan, but it will have probably more of administrative functions which need to be carried out. Yeah. The group coordinator will conduct the group coordination proceedings and develop a group strategy. The group strategy may provide various combinations of measures that synchronize the insolvency resolution or liquidation proceedings of the participating group debtors, corporate debtors. Such measures may be different for different companies, included in the strategy. The group coordinator will also assist the RPs, liquidators, and COCs of the corporate debtors so as to enable effective coordination amongst them. So more of an administrative job for the group COC. The strategy may include deciding upon what kind of assets are to be offered, what kind of resolution plan needs to be approved, or what kind of recommendations to be given to the individual COCs and so on. So more of a guidance kind of a role they will play. A group strategy should require the approval of all participating COCs by 66% of each of their voting shares respectively. Where a corporate debtor participating in the group coordination proceeding is undergoing liquidation, the liquidator should decide whether to approve the group strategy for the CD it represents. Once approved, the group strategy will be filed with the adjudicating authority and shall be binding on all parties to the group strategy. Now, in case of liquidation, obviously there will be no COC, so they are not even giving that to the stakeholders committee. They're saying that it should be dealt with by the liquidator, and the liquidator should decide whether to approve the group strategy for the CD it represents on the group COC. So once approved, the group strategy shall be filed with the NCLT and shall be binding on all parties. So again, group strategy could be something like a strategy for in what direction the process needs to go and so on. So that is, we need to again see why are they asking it to be filed with the NCLT? Because if they don't have the authority to approve a resolution plan, then that strategy on what lines are they supposed to approve, and then in what form and how it is going to go to the adjudicating authority for approval. Or is it only a filing? Is it only for information, or is it only for filing? So they're saying shall be binding on all the parties to the group strategy. So whether some approval is required from the NCLT to implement that strategy and so on, that again remains to be seen. Then a group coordination proceeding shall terminate if the group coordinator applies for a termination order, which may be on the grounds that the group strategy has been approved and fully implemented. The COCs and liquidators have approved such termination by requisite majority. The COCs and liquidators have failed to approve a group strategy, and the group coordinator is of the opinion that it is not feasible for participating group members to agree on a group strategy. Basic question which comes to my mind is, what is the difference between, in that case, a resolution plan and a group strategy? So group strategy may be obviously at a group level, but then a resolution plan could be at the individual CD level. But then if failure of a group strategy, if it's going to lead to a termination of a entire proceeding, that is a group coordination proceeding, then that will have that much of value. So it should have that much sanctity in law. Secondly, if the group strategy is fully approved and implemented, then that is also leads to the termination of the proceeding. So it is something akin to what we have in section 31 about a resolution plan. Once it is approved and fully implemented and so on, once it is approved, the CRP comes to an end. So this group strategy appears to be something akin to that, but we will have to see what all is expected to be covered in that. Then the cost of conducting group coordination proceedings should form part of the insolvency resolution or the liquidation process cost of the participating group members. Further, where group coordination proceedings are opened, an additional 90 days may be added to the time period for completion of the insolvency resolution process for the participating corporate debtors. So again, cost, there could be an issue. Cost of which entity for what whether it's going to be joint, I mean, the values are going to be common for the valuation of the assets of all the entities, or separate values, and all of those things again that procedurally we will need to see. Then the costs are going to form part of the CRP cost or the liquidation cost of the participating group members. So is it going to be at a group level or at an individual level? Then the CRP reporting also should be at a group level in that case. Then when the group coordination proceedings are opened, additional 90 days may be added to the time period for completion of CRP for the participating series. So suppose some CRP has already started, and thereafter a group company also gets added to that, and it becomes a group coordination proceeding, then additional 90 days will be given, because then probably the entire strategy will have to be reworked. The RP of the previous company and the RP of the new company will have to work together because of the group proceedings. So that's when additional 90 days is being proposed. Specific provisions to deal with perverse behavior may not be required, as provisions dealing with avoidance actions and fraudulent or wrongful trading under the code may be sufficient. Detailed provisions targeting perverse behavior in group insolvency scenarios should be legislated based on practice developed under the code in due course. So rightly, separate avoidance provisions need not be added, because they are in any case right now also when we are looking at avoidance transactions, which we are already looking at the related party transactions. We are already looking at the group transactions, and we are looking at the group entities also. And we are looking into the money flow. Say suppose a loan has been given in company A, and that has flowed out to 4 different entities. And from there it has gone to, say, the promoters' personal withdrawals or something. We are in any case tracking all of those things right now. So separate provisions for avoidance may not be required because it's already covered. And in case most of the legislation is also being developed now on avoidance transactions also, so that could be sufficient jurisprudence or as a guideline to deal with the avoidance transactions. Separate provisions may not be required for that. Then effective capacity building measures and increase in the use of technology during implementation will bolster the efficiency of the group insolvency framework. So of course, trainings will have to be given, capacity building will have to be done for the RPs, for the COCs also, because here for one entity, the COC is the king here. If it's going to be on a group level, then a company with say more assets and more loans and so on will obviously have a bigger voting share in the group COC, and then those things will also have to be seen that how those things work afterwards. So the capacity building measures will have to be done for the RPs, for the other stakeholders, for the COCs, and probably for the NCLTs also, that which cases can be considered as a group insolvency and so on. So a lot of effort and those things will have to go into drafting of this framework. Then this group coordination we covered. Yeah. Yeah, this we covered, I think. Okay, the report does not recommend the appointment of a single resolution professional for all group entities at the time of commencement of CRP. Instead, it recommends that the COCs of the respective CDs appoint a single RP if they deem necessary. So normally they should have separate RPs. A single RP is not recommended to be appointed for all the group companies. And also, if it is going to be starting at different points in time, again, one person obviously can handle it, but then each of them may have proposed a different person in the Section 7 application. The report also suggests that the solvent members of the group be allowed to participate in the group insolvency process on a case-to-case basis, or wherever it is deemed that it is necessary. Then the recommendation that the group insolvency be voluntary and flexible may run contrary to the substantive consolidation jurisprudence that has developed thus far by the Indian courts. That is where consolidation is directed at the request of the RP. So like if we see in the Videocon case, first it was the SBI which came up with this suggestion. So they filed an application to that effect, and in one or two applications were filed by the RP also, which supported that it should be done on a consolidated level. So it being voluntary and flexible may not work out that much practically, where there has been jurisprudence which says that there should be a substantive consolidation, which has been directed by the court itself in the first instance. Then a robust insolvency framework should define strict parameters for the initiation of substantive consolidation. So the law should state in which cases that substantive consolidation is possible. Otherwise, the norm should be the procedural coordination. Then the report has recommended that exclusive jurisdiction be conferred on the NCLT having territorial jurisdiction over any one of the CDs. However, the recommendations are silent on how the relevant NCLT will enforce its orders outside its territorial jurisdiction on non-cooperating CDs, particularly in cases where the RP has sought assistance or is pursuing applications for avoidance or preferential transactions. So that the report is silent on these, so probably it will come out in the say regulations, or there's nothing in the recommendations as such as of now. And this needs to be addressed on the lines, because as of now in section 230, 232, the NCLTs are giving directions, and they are passing on the cases. They are transferring the cases from one NCLT to other. So something similar can be worked out for these kind of cases for the implementation. But again, that we will have to wait and see. Although group insolvency will require coordination between multiple creditors, corporate debtors, RPs, and applications will have to be filed before the NCLT for initiation of group coordination proceedings and approval of the group strategy. The CBIRC has not recommended extending the timeline for completion of CRP provided under the IBC. So it still stays at 180 days plus those 90 days of one extension, because this may, if this will start at different points in time, then again reaching a group structure and reaching the group coordination and so on, that will probably require extension of the one which is already existing. So suppose a corporate debtor goes into insolvency and the CRP has already started. B comes into insolvency, say after 3 months, and C comes after another 2 months, and now it becomes a group proceeding. In that case, already these 3 to 4 months have been lost in the CRP for the corporate debtor. If it is considered as a group thing, then after that, that group process will start. So there should be something to extend the timelines in for the A corporate debtor. So those recommendations also need to be there, or it needs to be, at least that discretion needs to be given to the NCLT to deal with such things. So this is was about the recommendations which are there. So let us now look at the Videocon judgment, which has a lot of detail about the procedural aspects also. Yes, so this is the Videocon judgment, which talks about the group consolidation. So which was the first case in India for group insolvency. So see the number of applications which have been filed in each of these petitions. Number of petitions were filed for starting insolvency process against all of those entities. And SBI is the main applicant, and SBI was a common lender in most of the group entities, and they thought that it was a fit case that all of this should be consolidated into one proceeding. So they have gone for a substantive consolidation here, not for a procedural coordination. So they have treated everything as one entity, and accordingly they have sought to have only one insolvency proceeding. So all of these applications have been filed, and these are the entities against which are in consideration. So like we discussed, there were 15 entities against which this consolidation was sought. But out of this, the NCLT agreed to consolidate the proceedings for 13 of them, and 2 were kept outside of the process of the group process. There was one RP who was already appointed, and there are these other two entities who are there, who are group companies. So this Videocon, Telecommunication, Scale, and so on. These are the applications where the RP in those cases, they also supported the consolidation, saying because there is so much of interlinking, they are not able to, or they will not be able to effectively carry out a resolution process for these two entities unless there is a consolidation. So in that sense, they also supported the request for consolidation. Then these are other worker unions and so on who have raised various contentions in the process. Obviously, is trying to seek their own, protect their own interest. There a number of worker unions are there. The judgment is pronounced in August 2019. Obviously, so many parties, so the number of advocates and so on. So if we read each and every paragraph of this order as such, we see that a lot of thought has been put into why this application has been allowed, what is the jurisprudence and so on. So it is a very, very recent order, and it captures the essence of a group insolvency beautifully. If you see how they have drafted it and how they have given the reasons and the logic and why this needs to be brought in, even though this say that the working group committee at that point in time in 2019 or 20 before this order was passed, they had recommended that as of now we don't need a group insolvency regime. Let us first implement the normal CRP, that is the individual, that is the CRP for corporate debtors. And as time passes, as the law develops and so on, then we will move on to the next stage, which is probably the going for a group insolvency or a cross-border thing and so on. But how the judge has beautifully dealt with it, saying that there is never a right time, or in that sense, you know, that we cannot wait for the jurisprudence to develop and see how the laws settles down and so on. And then we go for this thing, for a new regime to come in, or a new regulation to be made in to deal with the issues which are right now, which are already coming before me. So he has made all of these observations, and then accordingly he has continued to pass this order, saying that a group consolidation is necessary, and he has laid down the law where he has given those 9 or 10 points, which are kind of a guiding force for us to decide whether a case is a fit case for a group insolvency or whether it should be treated independently. And one step further, not only for a group insolvency, but also for a consolidation, that is for a substantive consolidation rather than a procedural coordination. So those good, what we can say, it lays down the law which can be used till the time probably actually these regulations are brought in by IBBI for group insolvency. So this talks about, you know, what all applications have been filed, and some are in favor of the consolidation, some are against the consolidation, and so on. And the facts and so on have been given, how many applications are pending and so on. Now let us look at the background. So what is the thought which has gone in the mind of the judges when they decided to pass this order? So the facts before them, they have appreciated the background of the group companies and how they are group companies, and then what is the status of each one of them, whether insolvency proceedings have been filed, have been admitted, and so on. So they're taking a note of the status. So here they're saying it is worth to note that most of these companies, collectively referred to as corporate debtors, were proceeded against by the SBI. So again, SBI is a common lender amongst almost all the companies. SBI has proceeded under Section 7, and in a few the cases, some operational creditors had filed petitions under Section 9. And tables showing the status of 7 proceedings under IBC of the CD has been given. So all of these cases have been admitted, and our ARP or the RP has already been appointed in these cases. So if you can see, in each of the 15 cases they have discussed, all of the 15 cases have been admitted. So here is not a case where they are coming now for the first time and trying to initiate the CRP. The CRP is already initiated on different dates for all the 15 companies. And I think all of these are before the Mumbai bench only at that time. Yeah. Then Mr. Venugopal Dhoot, that is the ex-director promoter, had filed an application before the principal bench NCLT, praying that all the matters to the CDs must be heard by one and the same court of Mumbai NCLT. Likewise, another application was filed by State Bank of India before the principal bench, seeking the same reliefs as was sought in the said application, that is consolidation of all the CRPs of the corporate debtor. So two applications in the principal bench, one by the ex-promoter saying that here, if we see the court numbers in the fourth column, we see that they are before courtroom number 1, 2, and 3 different cases. So what application the promoter had filed was that let all of these be put before only one group. Before only one bench, so that only one bench deals with all of this. So it was more of a transfer of proceedings rather than a consolidation, which was filed by the promoter. And SBI had filed an application seeking that they be treated as a consolidated group. So that was SBI's application before the principal bench was for consolidation. Now the principal bench disposed of both the applications with a common order of October 2018. In the said order, the principal bench has transferred all the matters where the CRP commenced of the corporate debtors to this bench, that is, they have transferred it to court 2. Saying that it will serve the purpose of tagging all matters to avoid conflicting orders and any also dealing with the connected matters. In the same order, while dealing with the reliefs prayed for by State Bank of India, the principal bench has held that this order shall dispose of CA so and so and so and so. Prayer made in the first application is to issue directions for hearing of all videocon matters by the one and same bench of the adjudicating authority, NCLT Mumbai. The applicant has made averments that Videocon group of companies have many group companies against whom CRP has been initiated. Details have been listed and so on. So the details are given. Furthermore, petitioning creditor has also filed a petition under Section 7 in this tribunal against 14th company, CE India Limited, a mortgagor of the loan being CP number so and so, against the brand and the assets. On perusal of the aforesaid table along with para would show that the first lead matter, namely Videocon industry being CP number so and so, is posted for hearing before bench 2, which is headed by so and so. Likewise, 5 other matters are also pending before the same bench. It has also been pointed out that already another petition number so and so is also pending consideration before another bench. Prayer made in the application is that all these matters shown in the table should be listed before one bench. In the second application, prayer made is for the consolidation of all these petitions and issue further directions to treat the CRP as one in respect of all the Videocon group of companies. Then notice has been given and so on, so on, so on. Then we come to the operative part in para number 5. So here it says that last line, therefore it will serve the basic purpose of avoiding conflicting order and facilitating the hearing if the matters are posted before the aforesaid bench. Accordingly, we direct that the matter be posted before the aforesaid bench. Registry of NCLT Mumbai is directed to take steps and place the matters before the aforesaid bench. So now first order is saying all the matters are being transferred to court number 2. Then the other request that all the petitions be treated as part of one CIRP cannot be taken up by us. And any such request, however, shall be left open to be decided by the NCLT Mumbai. So the principal bench refused to deal with the second application filed by SBI and said that we are not dealing with it, but the Mumbai bench, if they want, they can deal with it. So accordingly, the application of SBI filed in the principal bench for consolidation was disposed of. And the other application of the promoters to transfer everything to the same court was upheld. Accordingly, all the applications now came to be heard before the bench number 2. Now, this is the application which was filed by SBI. SBI filed a separate application here before the NCLT, Mumbai bench, because that, as per the directions of the principal bench. That is this IA number 1306 of 2018, which was filed by SBI seeking consolidation of the CRP of all these 15 entities. So the 15 entities which are listed out, they're saying each of these companies were promoted by the Dhoot family and thus form part of the Videocon group of companies. The list of creditors for all of these companies is also given here. So who all had lent in addition to SBI, all of these banks were also the lenders for all of these 15 companies. Then a reference to the principal bench order is also made here. And in the application, again, the references have been reproduced here, that what is a substantive consolidation and so on. So those references have also come in here, that a substantive consolidation of the CD into single proceeding solely for the purpose of CRP and how to deal with it, with the assets and so on. All those things have been dealt with. So this is what had been asked by the SBI in the application before the principal bench. Now here they're talking about the background of the corporate data. So the one of the factors in deciding substantive consolidation is the intricate relationships between the groups, the group constituents. How closely are they interlinked? How closely is the business interlinked? We saw those criteria of using common infrastructure, using common resources, using common logos and so on. So those criterias, and whether it is in the same line of business or some entity is there which is completely in a different line of business. So all of those factors have been considered in the background of these corporate debtors. For all of these 15 companies, they have said into what is the activity, what they are carrying out, and what is the relationship, like it's a subsidiary or it's a holding company and so on. So those have been discussed here. So what has been submitted by SBI as a basis for consolidation is that these corporate debtors, that the business activities of each of these corporate debtors are inextricably linked and are intertwined. There is tremendous interdependence amongst each of the corporate debtors, and because of which there was a rupee term loan, which was a RTL agreement referred to in this order, which was there, which is like a common order, or which is like a common agreement. So most of the corporate debtors in this group are a party to that rupee term loan agreement. It was a joint borrowing in that sense. Then in addition to that, there was obviously working capital facilities and other things which have been availed of by each of the individual corporate debtors. But the common factor was that RTL. Then again, the history has been discussed, what all happened and how the loans were defaulted and so on. And how as per the terms of the RTL, it is considered as a single economic unit, and the financial statements are also filed on a consolidated basis for the purpose of only for the RTL. So it's not only for the purpose of the statutory compliance, but also for the purpose of under the loan obligations, they are required to treat it as a single economic unit and file the consolidated financial statements for all of these borrowers together. Now, different submissions have been made by the representative for SBI, saying, giving the facts of the case. We need not go into all the details there. So they have discussed the shareholding pattern, how it shows that there is a unity of interest and ownership. So there's a chart which has been submitted. So if you see, there's this chart which is there, which talks about the cross holdings. So all the 15 companies, what is their cross holdings, what is their holding, who's subsidiary and so on. So there's a complex chart which is there, which talks about the cross holdings of the corporate debtors by each one of them. Then which shows that how interconnected they are. Then again, there's a reference to the RTL and the common transactions which have taken place between all of these entities. Now, what SBI is also submitting is, as the object of the code is a resolution and rehabilitation of the CDs as a going concern as opposed to liquidation. It is believed that if a substantive consolidation of the CD takes place, assets of all or a group of the CDs will be able to be offered to a resolution applicant under a comprehensive resolution plan. This may result in the realization of best value for each of the CDs, which in turn will benefit the stakeholders. So their contention was that some of the CDs are such that they may not even be able to get any resolution plan, because their assets are probably charged to somebody else, or there are no assets in that entity, which is what which would fetch a resolution plan. As against that, if it is considered on a group level, on a consolidated level, then there is a better probability of getting a resolution plan for the whole group, and all the assets and all the stakeholders will in turn benefit out of that, and the corporate debtors will benefit out of getting a consolidated resolution plan. Here, SBI has further submitted that the assets and liabilities are also completely knotted into each other, and if separated, probably they would not fetch as much value, or not fetch a plan which may be in terms beneficial for the corporate debtors. Then there's a reference to the US bankruptcy laws, where we discussed that in the Owens case also. What are the criteria which need to be taken into account for a substantive consolidation? the degree of difficulty in segregating and so on. So these criteria we discussed. Then the SBI also in the arguments itself, they suggested that how they can how the bench can direct further substantive consolidation, or how it can be done gone about. So they have said that pooling in the assets of the corporate debtors may be recommended, or appointing a common RP for all the corporate debtors. So how to go about the substantive consolidations? Those recommendations have also been given by the Council for SBI. And again, they have suggested that the CRP commencement date, because again, there are different CRP commencement dates. If you know, from what we saw from the chart which was there were different CRP commencement dates. So let there be only one date, and so that it becomes easier for the RPs also to deal with that process, and for the timelines to be followed. Then again, if there is no substantive consolidation, then lesser value may be fetched, and some CDs may go into liquidation and so on. So all of those have been, those arguments have been tendered in support of the consolidations. Again, the reasons have also been given why is this a fit case to be considered as a substantive consolidation. So joint lendings, committee of creditors are common, and single economic unit and so on. So the criteria what we saw, all of them has been discussed here. Now they say that there is a precedent in insolvency, group insolvency under UNCITRAL model law, USA, Germany, European Union. So we discussed those, how they have been dealt with there also. So they have that, those references were also submitted to the NCLT in support of the substantive consolidation. Now here they talk about different applications which are there in support of the consolidation. And from here on, they're talking about different applications which are there, which are against the consolidation. So both the submissions have been considered. So this is like who said what and all of those things. Those submissions are given here. Then whatever judgments of foreign courts have also been submitted. So the Learned Council of SBI has tendered certain English case laws on the issue of consolidation of CRPs, and he has given these 8-10 judgments for reference of the bench. Then there's a detailed discussion about how each company is a group entity, and how each company is so closely linked, and what is the status of the loans and lenders and so on for each of these entities. Then there's a borrowing from other judgments. Then each of the pending applications also has been dealt with, because those need to be disposed of before this application can be finally decided. Now we come to the findings. After all of these applications have been dealt with, the findings on the main application regarding consolidation. So here it is interesting to note, the remark which the honorable member has made while starting with the findings in this judgment. That a philosophical opening remark before addressing this interesting issue as emerged out of the discussion made herein above is that if in life an attempt is made to avoid a crucial situation, either by ignoring it or deferring it, this is experience that very situation or problem resurfaces so fast that it compels to deal urgently, leaving no scope for avoidance or for any more deferment. This thus leaves no alternative but to tackle the bull by the horns. And the reason why I'm saying that, why I'm making this observation, is because the report of the Insolvency Law Committee has stated in this paragraph that right now we should not deal with the group insolvency matter, but we will let the insolvency law first take roots, and after that we will deal with the this insolvency matter, the group insolvency matter, later on, once the system is established. So the judge is humbly differing with that and saying that now the time has come that we need to deal with all these things also. So here he says in the next paragraph that at that point in time it may have thought that it was too soon to introduce, but the jurisprudence on insolvency code has developed very fast in the last 3 years. And the problem of consolidation has also cropped up much sooner than expected in this group of cases. So pressing that it so pressing that it cannot be avoided or deferred, and no option is available to this bench to declare that in the absence of any specific provisions in the code, the issue of consolidation is premature, so be not dealt with. Nonetheless, I cannot hold that in the absence of law, the question of consolidation need not be addressed. So he's going beyond, he's saying that in that sense, I'm going beyond my reach. I am aware that this approach shall not be appreciated being against the natural justice. Equity demands to give a verdict on an issue raised by the litigants before a court of law, but definitely within the four corners of law without transgressing the jurisdiction as prevalent currently. It goes without saying that the decision herein below is going to be based upon the merits of this case, supported by case laws pronounced in the past and evidence on record. Undoubtedly, the treatment of group companies for the insolvency purpose is a complex subject, as appropriately observed in the report. Lifting of corporate veil for insolvency purpose may affect the corporate debtors entity significantly, but considering the high stakes of the stakeholders and the lengthy arguments raised by various parties demanding a verdict urgently on the issue of consolidation, no choice is left but to take the call, although with due care that not to exceed the jurisdiction enshrined in the insolvency code. So he's saying that I'm bound by the code, although there is no provision, but I'm going to find out something or rely on something which will help me to take that decision. Then he is discussing the preliminary issues and so on, why this consolidation is necessary. Now, para number 78 is important, where he has discussed, or he has listed out this 15 points in this judgment. On what basis should we take a call whether a consolidation is necessary? So what is the points which need to be taken into account? So before arriving at any conclusion on consolidation, the existence of certain ingredients are necessary to be examined. That is one, a common control, common directors, common assets, common liabilities, interdependence, interlacing of the finance, pooling of resources, coexistence for survival, that is the coexistence of the corporate debtors for survival, intricate link of subsidiaries, intertwining of the accounts, interlooping of the debts, singleness of the economic units, cross holdings, interdependence due to intertwined consolidated accounts, common pooling of resources, and so on. And this is not an exhaustive list. These are the elementary governing factors prima facie to activate the process of consolidation. So here this list is given, and on the basis of this list, he then proceeds to examine each of the corporate debtors, whether they are falling into, whether they are satisfying these conditions, what he has laid down in these 15 principles. And then there's a reference to these various judgments, which is in support of the consolidation, and what is the rationale which has been used in that. Again, what we saw here was this consolidated, in the Owens case, so some similar guidelines are given here. Yeah, so now he says that after that, he has dealt with all of these cases, how the companies are, there's a common control, common directors, common assets, and so on. So he has listed all of these, the 15 points here, and how in each and every case, it appears that this is a consolidated group. So what he's saying is that the parameters again to be discussed, he has discussed those in details here in these, the parameters in fact are the factors to distinguish the units in two categories, and he has then discussed these two entities. So here again the question was whether all the 15 have to be consolidated or whether some entities need to be kept out. So he has laid down the guidelines here in this paragraph 82 and 83, saying what should be the basis for consolidation. So if we note that out of this 15, only 13 were consolidated and 2 were left out. So there here he has he has discussed why those 13 are being consolidated, or what should be the grounds for consolidation of those corporate debtors. So here they are concluding that for the purpose of carrying out the businesses, these two entities are not interdependent. So these two are probably having different businesses and they are having different kind of structures and so on. So because of which they need not be consolidated in along with the other 13 entities. So these two are left out, and these two are said to be not required to be consolidated, but they will be functioning separately. So CRP proceedings shall run independently by denying consolidation. So for these two entities, Trend and KIL, they have said that they don't fit into the consolidation criteria. So we are keeping them as separate CRP processes. Now, finally, as a consequence of all this, para 85 is now the operative part, where they say that the consequence of the above decision is that out of 15 entities, CRPs of the 13 entities are directed to be consolidated, and those two others which are left out will be treated as separate CRPs. Now, as regards appointment of IRPs, they are saying that in these consolidated cases, while admitting the petition, name of so and so is largely been approved. So he is now directed to take over the process of insolvency henceforth and complete expeditiously and file progress reports and so on. So for 13 entities, he was appointed as the IRP. For the other two entities which have not been consolidated, there are different IRPs who have been appointed. So whoever was the IRP appointed in that case, they have been continued. And for the first 13 consolidated entities, a common RP has been appointed. The RP is hereby directed that in case of 13 corporate debtors listed above, consolidation is now approved. Therefore, on the basis of the consolidated balance sheet of the group drawn as on 31st March 2017, directed to be updated as on 31st March 18, and thereupon the IM is to be prepared at an early date so that urgently expression of interest can be invited. So all the 13 assets of 13 entities, liabilities of 13 entities and everything will be pulled in. The information memorandum will be prepared for 13 entities, not for individual entities. And it will be as though all those 13 entities is one corporate debtor. So whatever we prepare as the IM and so on for one entity, the expression of interest, the RFRP and so on, everything will be now prepared on a consolidated scale for 13 entities together. For the other two entities, it will happen in the normal course of business, like what we normally do for independent corporate debtors. Now, as regards CRP period, so as we have observed, there are different dates for starting of the CRP for each of these entities. So what they have said is that since the CRP has already started on different dates, but different applications have been filed in almost in each of these cases. So the period from that date of admission till this date, that period should be excluded for the period of computation of 180 days. And whatever is the balance period that will start running from today. And accordingly, all those will run parallelly. So then that also gives the RP more time to deal with these 13 cases together with having a common date to be dealt with. So this gives the procedural or, I would say the practical solutions also in the sense of what dates to be taken and how to go about it, what kind of actions are required. Because imagine this was in 2000, no, this was 5-6 years ago. At that time, even the law had not been developed to this extent about what are the roles and responsibilities and so on. So in that sense, we have a fairly complete judgment which talks about all of these. You're not able to see my screen?
No, ma'am.
Oh,
Oh, so you were not able to see the judgment?
We were able to see only some icon, ma'am.
Are you able to see it now?
Yeah,
Yes.
now we can see it.
Oh, okay. I saw the chat box now. Okay, I'll just, there are some portions which I have highlighted here. So this is a 52-page judgment, and as I mentioned, some discussions have taken place about the different applications which have been filed, what are the different stages of CRP of each of these and so on. I'll just quickly run through it again. Yeah. So not repeating all this. Yeah, so the order talks about all the pending applications and the CRPs and so on. Who has filed what? Then there's a background of the, this was the table I was referring to, which talks about the different entities at what stage of the CRP they are in, and the status, whether it is admitted, not admitted, and it is before which bench of the NCLT. Then the particulars of the applications which have been filed. And this 1306 of 2018, this is the application which was filed by SBI before the NCLT Mumbai now for a consolidation of all the applications. The list of creditors, the list of corporate debtors has been given. Then there's a lot of discussion about the background of the corporate debtors, what business they are carrying out and so on. So this is dealt with here. Then the submissions of SBI for substantive consolidation. So what we discussed, they have given those points in detail. There is this chart showing the shareholding of the intricate linking of cross holdings and so on amongst the group entities. Then other submissions by SBI about why the substantive consolidation is necessary, and the some guidance as regards the Owens case, which talks about in which cases the substantive consolidation should be done. Then they have dealt with all the other applications. Then this is where the judge talks about why he's trying to give this judgment, even though there is no provision in the law as of now. And the 15 pointers which he has given about when the consolidation should take place and what are the circumstances in which that should be allowed. These are the 15 points. Then there's a discussion on all the US and UK cases which had been submitted by SBI in favor of consolidation. Then here there's a discussion about how the these 15 criteria which have been laid down are complied with in this particular case. So how does it favor a consolidation? And after that, there's a discussion which talks about why these two entities out of the 15 entities, the two which have been left out, why they have been left out, because they don't meet the criteria, and that is not a fit case for consolidation. So those two CRPs should run separately. And the final conclusion, 13 are being admitted, the IRPs, what is to be done by the IRPs, what are the next steps to be taken, and so on. Okay. So now we come to the chat box. So we come to Mr. Sharma's question. Yeah. So you have said that you were recently engaged as IRP in a group insolvency real estate matter, presently under stay. So,
Yes,
sir,
ma'am.
can you just please tell us whether you were appointed like for separate entities or how is it?
In fact, application was filed for all three companies in one application only.
Okay.
And there is one order for going for commencement of CIRP.
Okay.
And
So all
since
the
the
three
company,
CRPs are starting on the same date.
Yeah.
Like it's a one process only for all the three entities.
one process for all.
Right.
And the relation between all these three is first company is the allottee of the land. The Noida Authority allotted the land to a company. Then A and B, they enter into a collaboration agreement. At that stage, B was subsidiary of A. So that was the relationship.
Okay.
Hello.
Yes. So we can hear you.
And C again, after a gap of around 5 years, then they both A and B, they enter into another collaboration for with the C. I could have access to one CAG report of Noida Authority, whereby I can say that all three companies have collected funds. And majority of the funds were siphoned out to the group companies of the corporate debtor. First company. Hello.
So we can hear you.
Can you
Yes,
hear me?
yes. Yes, we can hear you, sir.
So now all these three companies, I'm expecting a claim from the financial creditor in all three companies.
Yes.
Please suggest me how to go about that.
So I would say that once the NCLAT vacates the stay or whatever happens, and assuming that the NCLAT, so the stay is on what grounds? The appeal is on what grounds?
Pardon me?
The appeal is filed on what grounds? That a group insolvency cannot take place or
Appeal is
some other
for
reason?
for settlement by a C company.
Right. So it has nothing to do with the merits of the case about how a group insolvency can start and so
Only
on.
thing that they said, okay, we want to settle it down, but this issue was again before the NCLT also, and that time NCLT has not allowed that settlement.
Okay.
Because the financial creditor, they have not agreed for settlement.
Right. Right. So, sir, in my view, what the directions what have been given to you in the NCLT order is it is for a group insolvency, consolidated group insolvency of all the three entities.
All
So
three entities.
So you will have to have a joint insolvency of all the three entities.
That's right.
Giving particulars of all the three entities separately. I'm sure probably you have already gone ahead with the public announcement.
Yes, yes, sir.
Right. So where you would have given the particulars of all the three companies.
Yes, all three companies separate forms were published.
Right, but your COC will be one only once you accept the
Okay.
claims. In my view, the COC would be only one.
It means the only option is this is substantive consolidation.
Yes, because your order is saying that.
Okay.
I'm assuming that your order is saying that it will not be three separate. So you have not been appointed like three as IRP in three different entities. It is only one appointment.
Only one appointment.
Right. So that would be a substantive consolidation, and you will have to deal with all the three as one unit only.
Okay. Okay. That's great.
Because I think that will be simpler also for you.
Yes, that will be good.
Yes.
But
And
in any case, I'm happy that I got this case to deal with.
I was
group insolvency.
yeah, I was
Yes.
going to say that you're very
Yes, yes,
lucky that you got this.
Because professionally, I'm going to learn a lot from by handling this group.
Definitely, sir.
Yes, yes.
Definitely. And I would
And
say it would again be a very landmark kind of a thing because apart from Videocon, I don't think there are many other RPs who can say that they have actually handled a group insolvency.
That's right, ma'am. And in case of any problem, professional like you are available. So
Sir, we
I'll
are going to
definitely
learn from
approach
you, sir. We will
Yes,
learn
ma'am.
from you for a group insolvency.
Definitely.
I think those there are very few practical examples what we have in
Yes,
how
yes.
to deal with this.
That's
All
right.
the best, sir. And we would
Thank you very
definitely,
much. Thank you
once
very
you
much.
finish this
Thank you.
assignment, probably you should take a
and you-
session on how to deal with it.
You have explained this issue in a very intelligent manner, I will say. Everything
you,
is
sir.
crystal clear to me now.
Thank you, sir. Thank
Yes.
you. I hope it's useful. Okay, is there any other question? Or anybody wants to share their own experiences if they have handled something similar, so we all will benefit from that. If not, then probably we can call it a day. Madam? Anjali, madam, you there?
Yes, ma'am. Can we conclude now?
Yes, we can conclude. I think there are no other questions.
Thank you very much, ma'am, for such a nice presentation. And please share the PPT for this.
I will do that, ma'am. I'll share the PPT. And I also prepared a note on the CBRC report, so that also I can circulate. Probably, sir, it will be helpful for you in the assignment.
Okay, ma'am. Thank you very much.
So thank you, ma'am. We can conclude.
Thank you very much, ma'am.
Thank you. Bye. Good day.
Thank you very much, ma'am.